Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners who want to hear the latest from the frontier of these laws and regs. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Civil Practice and Procedure Committee of the Antitrust Law Section. The topic? Criminal liability under Section 2 of the Sherman Act. Today's antitrust practitioner has spent their career accustomed to a straightforward bifurcation of the Sherman Act. Section 1, which targets practices such as price fixing, bid rigging, and market allocation, comes with potential criminal liability. Section 2, which targets monopolization or attempts to monopolize, does not. But this partition is no longer reality, as foreshadowed by Assistant Attorney General Jonathan Cantor during remarks in January 2022, where he promised to use, quote, every available tool, unquote, to promote competition. In March of 2022, then Deputy Assistant Attorney General Richard Powers roiled the antitrust bar when, appearing on a panel, he said that the division was prepared to bring criminal charges in Section 2 cases. Those who prize original intent would do well to note that historically, the DOJ brought a number of criminal antitrust cases in the first half of the 20th century under Section 2, the text of which explicitly contemplates criminal penalties. But in 1977, the DOJ abruptly stopped and pursued only civil remedies in Section 2 cases thereafter. That changed in late 2022, when on October 31st, the DOJ announced a criminal monopolizational conviction in the United States v. Zito, where the defendant, the president of a certain type of highway construction service in Wyoming and Montana, pled guilty to attempted monopolization. Sentencing will take place in February 2023. The defendant faces up to 10 years in prison. This was the first Section 2 criminal resolution in nearly 50 years. Policy shifts are not without precedent. In 2016, the Antitrust Division announced a shift in its intent to prosecute wage-fixing cases criminally. In fact, you can almost draw a direct line from there to this as an inevitable continuation of treating violations of antitrust law more seriously and enforcing the Sherman Act as it was originally written. Of course, the defense bar will raise concerns when they change the thermostat of injustice. Yet this policy shift does raise some unsettled questions. One of these open questions is, since monopolization is typically not a per se violation of the Sherman Act, how would a criminal case proceed under rule of reason? Criminal defendants are entitled to fair notice that their conduct is illegal. Could you challenge unpredictable application of Sherman 2 as void for vagueness? Another open question, what are the penalties associated with a criminal Section 2 violation? That is, how long of a prison sentence will the division recommend? And also, 2 of the last 3 criminal Section 2 cases from the 70s all coupled Section 2 charges with Section 1 charges, and the third coupled it with a different criminal charge. In Zito, the Section 2 charge was paired with a traditional Section 1 market allocation claim. Well, criminal Section 2 claims need to be brought alongside more traditional criminal Section 1 claims or other criminal charges. My co-host today is Travis Wheeler, a member of the Nexsen Pruet law firm and an adjunct professor of antitrust law at the University of South Carolina Law School. And our guest is someone who has been in the thick of the Antitrust Division's revival of Section 2 criminal liability. Travis, glad to have you here.
Thank you, Anant. And it is my pleasure to introduce Richard Powers. I think if there's one thing Richard doesn't need, it's probably an introduction by me, but I'm going to do it anyway. Richard is now a partner in the New York office of Fried, Frank, Harris, Shriver, and Jacobson. Prior to joining Fried Frank in September of 2022, Richard served over 13 years in the Department of Justice, most recently as the Deputy Assistant Attorney General for Criminal Enforcement of the Antitrust Division. He also served as Acting Attorney General for Antitrust for the first year of the Biden administration. Richard is a graduate of the United States Military Academy, fresh off an overtime win over Navy, and served as an infantry officer in the U.S. Army prior to embarking on a legal career. And so today we are talking, hopefully from a little bit of a civil perspective, about kind of a domain that, for most of the last 40 or 50 years has seemed, correctly or not, exclusively in the civil realm. And as I think Anant has, laid the groundwork, that has changed in 2022. And I think just as is an initial question for Richard. Why are we here? What was it that, if you could tell us, that the DOJ saw that, that needed, that needed buttressing in this manner?
Sure. Well, first of all, thanks for having me here to be a part of this discussion, Travis and Anant. It's great to be with you all, and with all of the listeners. I'm especially grateful for highlighting the recent Army win over Navy. That's very important to me personally. And then I should say at the outset, what we're going to discuss here today, my views are my own. And they certainly, nothing I'm going to say here today should be taken as a comment on anything that was going on, at DOJ, other than what's public, of course, now. But, what's going on at DOJ. And really, I'm just trying to stick to my interpretation of their public statements at this point and the law that exists. So with that caveat out of the way, so I don't have to give that answer every time. Let me get back to your question, Travis, which is, why are we here having this podcast today? And I think it goes back to something Anant highlighted in his opening, which is, I think we're all aware of the movement afoot to really kind of engage in robust competition enforcement in the United States and elsewhere around the world. And I think if you look at what Assistant Attorney General Jonathan Cantor has said publicly time and again, reinvigorating Section 2 enforcement is a key part of his agenda. And I think, part of aggressive Section 2 enforcement is full enforcement of the statute, breathing full life into the statute, right? And that includes criminal enforcement. And I think when you take that sort of step back and say, okay, yes, we haven't seen criminal prosecutions in the area since the late 70s. But if you look at the long view, the long arc of the Sherman Act, I think the number is somewhere around 170. There's different assessments, but I think there's been about 170 criminal Section 2 cases. So it's something that went on for a long time. It stopped, the Antitrust Division ceased exercising its prosecutorial discretion in favor of criminal enforcement in the late 70s for some period of time. It's obviously picked back up again. But I think it's all consistent with what we are hearing from the administration, the prioritization of antitrust enforcement, the prioritization of monopolization enforcement, and the fact that it's sitting, on top of a long history, albeit not a recent history, but a long history of criminal enforcement.
And I know Anant had mentioned the Zito case, and that factually involves sort of a proposed market allocation, I think, between two participants. But could that have been brought as a Section 1 claim? And if not, why not?
So this is going to fall into that category where I want to be careful about how I talk about specific cases, especially Zito. But I do think so let me see if I can answer it this way. I think if you look at what is public, I think it's instructive in terms of telling you what could the Antitrust Division have done or not done. I think we all know that if you're going to charge a standard Section 1 per se market allocation agreement, that you need to, in fact, have an agreement, right? And so, I think there is history of cases being charged where there was an invitation to collude, but it maybe fell short. So again, not commenting specifically on that case, but I think, looking at the charging instruments and whatnot are instructive. And I think, there have been circumstances in the history of criminal prosecution of Section 2 where, it was, what looked like a Section 1 violation, per se violation, but maybe it fell short because it was an invitation that was rebuffed by a competitor.
So words matter, I suppose, and it is possible, I think, to for a firm or an individual, to extend an invitation to collude that, if accepted, would give that individual or firm market power. That invitation in and of itself can be viewed as a criminal act. Is that overstating?
Yeah, I think that.
Okay.
No, I think that's right. And I think Travis, you kind of layered on one of the important parts of that, which is market power, right?
Mhm.
And monopoly power. And I think when you're sort of pivoting from Section 1 to Section 2 enforcement, that aspect of monopoly power, as you look through the cases, I mean, that's an important part of it. So not, in my mind at least, not every market allocation agreement or price fixing agreement would give to a cross-section violation, but where you have the requisite sort of facts establishing market power or the ability to achieve that sort of market power and the intent to achieve that position, then I do think you start to have the Section 2 liability alongside the Section 1 liability.
Okay. What under Section 2, there's three sort of separate offenses. One of which is conspiracy to monopolize, which overlaps a good bit with Section 1, and I want to try to stay away from that today, and really want to kind of drill down into some hypotheticals based on former real cases, all civil cases, and talk about it in terms of either monopolization or attempted monopolization, and kind of test your reactions for whether or not these factual scenarios, if they arose today in the context of defending a civil case, might implicate some criminal exposure or bring criminal exposure. So first up, just kind of wanted to start with Lorraine Journal. It wasn't a criminal case, but I think if you were trying to explain the concept of monopolization to someone, you could do a lot worse than starting off with Lorraine Journal. And I think that is a pretty clear example of one firm attempting to destroy its only real rival. As a refresher, Lorraine Journal was a local newspaper in northern Ohio. I think there was a separate Sunday paper, but other than that, it had essentially unfettered market power in the dissemination of news and advertising in Lorraine. And I think it was like 99% of the households, in 1950 or 51 that got the journal. An AM radio station, which was the only radio station in the area, began broadcasting from Elyria nearby, and the journal's response to that was to refuse to accept any advertisements from a firm that was advertising with the radio station, or that it even thought might be advertising with the radio station. And so, if we stop right there, with nothing more than just, a newspaper with market power requiring a pledge of exclusivity from its advertisers, is that enough to give you any pause if you are kind of defending the journal from the lawsuit, say brought by the radio station?
So, I think, and I'm going to say this probably a lot today, but, this is obviously very fact specific. But I think where, you take a Lorraine Journal fact pattern and maybe compare it to like a Kansas City Star case, right? So that's a case from out of the Eighth Circuit from the late 1950s, very similar, I think, in terms of what was going on in terms of the local newspaper using a series of exclusionary agreements to eliminate competition. And that was a criminal case, right? That went to a jury, the jury convicted, and the circuit upheld the conviction. There was no sort of price fixing allegation, as I understand the case. There was no sort of Section 1 violation that went alongside it. So the question I think we're getting at is sort of like, how do we kind of parse the line between those two? And I think, it's going to come down to probably two things. One is evidence of clear intent, right? Clear intent to monopolize to sort of eliminate the competition. And then I think egregious conduct, and I'm using those terms because I think those have been cited in subsequent cases by the Supreme Court, talking about when you're outside of the per se territory, Section 1 violations, where should criminal liability really attach? And so I think, in the Lorraine Journal fact pattern, I think, if you have, and it gets into what sort of evidence does exist, but if you have that clear evidence of that intent to monopolize, coupled with enough predatory or exclusionary types of acts, then I think you are running the risk. I think you are kind of down the spectrum towards criminal liability and away from perhaps maybe more routine types of Section 2 cases that really don't give rise to criminal exposure.
And I think kind of looking at that Kansas City case, there may have been a little bit more of a checklist of things that you could point to as bad acts. But if I am your client, I'm the journal, and I'm coming in, and and I just all I did was, the radio station started broadcasting, and I said, okay, you got to pick. If you want to advertise with me, it's all on with me. Is that different to you than what actually occurred, which was not only, that pledge of exclusivity, but also, we paid a guy to stay up all night listening to the radio station so we could catch people that were advertising on both? Is that sort of a bad act that you were, that might move the ball, more into this sort of criminal area?
Yeah, I think what you're describing in terms of the former, where it's just the exclusivity, I think you don't see that in the history of Section 2 criminal enforcement as just sort of that discrete fact pattern giving rise to liability. Maybe I'm missing something, but I don't, that's not my recollection. Right. And I think an important part of this, as I think about what the DOJ is going to have to try to do moving forward with this, is you want to be able to kind of point to cases that are similar to the case you're bringing, and say, look, this isn't, a new form of liability. This is something that has been prosecuted before. And I think, to the other part, I think it's asking the follow-on, if you're talking to a client, asking those follow-on questions of, what was your motivation, and what, were there these other mechanisms to sort of police the exclusivity? Were there threats being made? What were the sorts of conversations going on? Have you gotten in trouble for this before? Right. And I think that's something that the courts have discussed too, which is, are you a recidivist? Is this something that, you were found liable on previously? And again, some of this sort of circles around, to me, and I'm using hand gestures on a podcast, so I'll try to stop that. But the idea of intent, right? What were you intending to do? What was sort of your understanding of whether you were competing on the merits versus, doing something that was more clearly anti-competitive, right? And I think that's going to be important for the line between where there would be criminal versus civil enforcement.
And is it reading too much into the Lorraine case to say, okay, that was 1951. That was during a period where there were still criminal prosecutions of Section 2 conduct, and that perhaps that wasn't quite egregious enough at the time to merit that. That it was an action brought by the United States.
Yeah, I think it's always tough to go back and try to guess what was in everyone's mind, but I think that's probably right in terms of the more egregious the conduct. That seems to be the trend line. The more egregious the conduct, the more clear the intent to monopolize, the anti-competitive intent, the closer you get to having criminal liability. So I think that's fair.
Okay, so kind of moving on to the next sort of hypothetical, and this is going to be a little bit broad, but I want to talk about tying, everyone's least favorite aspect of antitrust law. But it was viewed, there was a time where tying was viewed as like one of the supreme evils, of the dominant firm. Not so much today. It is usually brought as a Section 1 case, but there was a case in 2018, and it was Ozzy Osbourne was a class rep. He filed suit against the owners of the London O2 Arena, and the Staples Center. And I, what was really unusual about that case, I think, is that it turned Latham's Dan Wall into a plaintiff's lawyer, ever so briefly. But there was one indoor arena in London. It rains a lot in London. If you are someone capable of getting 20,000 folks to a concert, that's your one place to play in London. More options in Los Angeles, but and there was actually, I think they called it the Staples Center commitment, that if you were booking a gig and you were going to play in London, if you were going to Los Angeles, and there's some 25-mile radius, I think you had to book Staples. You couldn't do the Forum Center, or another local arena. And I think just from the facts of that case, and just arenas and how arenas are used. They're not just for heavy metal rock concerts. However effective that tie is, it's probably not going to drive out other arenas in Los Angeles. But I think that is it was a pretty good example of a tie that might fail under Section 1. And so I thought I would, ask that, if you were representing Ozzy in 2022, I'm sorry, not Ozzy. If you were representing the arenas, are you concerned about potential criminal exposure for just a pure tie?
Sure. So I think looking back again, I'll keep coming back to sort of what's out there in terms of the cases, but I think where it seems like tying has shown up in the past, it's sort of and also, this was going on, right, in addition to other predatory activity, exclusionary acts, right? It's sort of like, let's pull out every anti-competitive tactic in the toolkit and use it to monopolize this market. And tying is one of them. But comparing a standalone sort of tying issue to tying as one of a multitude of ways an entity is trying to monopolize, I think those are distinct. Those are probably distinct fact patterns. And again, I don't know that I've seen a situation where there was maybe there was 100 years ago and I'm misremembering, but criminal enforcement of a standalone tying claim. But I think again, I think it's probably a little outside of the range of what I think might give rise to criminal liability. But on the other hand, again, it very much depends on the facts. Have there been prior issues? What was the intent? Were there threats being made? Those sorts of things that you kind of have to flesh it out. But sticking to that specific case and those specific fact pattern, I think, like I said, I think my instinct is that tying would probably have to be part of another broader set of facts to really get closer to criminal liability.
I'm going to try one more question on tying, because I think I see the writing on the wall. But if you've got a client and there was an internal meeting and they decided, okay, we've got an absolute monopoly in product A, we're competing in product B, we can tie those together. Everyone's gonna, everyone needs product A, and we're gonna have ourselves a second monopoly in product B, and that seems to bear out. There is a dangerous probability that tie by itself will succeed. Rare as that case may be. If you're defending that client, is that something where suddenly you might be thinking about Fifth Amendment issues, or is there a concern at that point if that's the only tool in the box, but it's a sufficient tool to create a dangerous probability of monopolization in the tied product market?
Yeah, I mean, this is always the danger with hypotheticals, is that, especially recently from DOJ, your instinct is always to stay away from them, because the reality is, it's just so fact dependent on things like the intent and the egregiousness of the conduct, and is the law pretty clear about the fact that sort of predatory or exclusionary conduct is a violation. And when you talk about intent, intent's a very, as a former fraud prosecutor, I can tell you intent's a challenge when you start talking about proof, because as courts say time and again, it's difficult to get inside somebody's mind, and so you're oftentimes left trying to argue inferences from conduct, and those are tough cases. And so I think that is instructive, because I think my sense is that you've got experienced prosecutors at DOJ that understand those sorts of concerns, and I think recognized what I suspect that they recognize what the courts have said about where you have to draw the line between criminal and civil enforcement under the Sherman Act, and they will stick to those areas where it's been pretty clear in the past.
Okay, so one more that I'd like to cover, just because I think factually it's certainly more interesting than tying, is skiing. Aspen skiing, I think everyone has some familiarity with that case. It was a unanimous Supreme Court case, fairly unique facts. But it's kind of just a brief recap. You had the owner and operator of 3 of the 4 skiable mountains, on Aspen. They had a long-standing arrangement with the owner of the 4th skiable mountain to offer a joint weekly pass that allowed basically out-of-towners to come and use any of the 4 mountains, or ski any of the 4 mountains on any given day of the week. And just to kind of streamline the facts a little bit, on the front end, about a year before, everything kind of blew up, Skico, owner of the 3 mountains, sort of quietly reintroduced a pass, a 3 mountain pass for its own mountains, largely ignored. Consumers didn't want to get a 3 mountain pass when there's a 4 mountain pass. Didn't make a lot of waves. A year later, Skico management recommends to the board that we should discontinue this all Aspen pass with Highlands. And I don't know if this is relevant for today's discussion, but I wanted to throw it out to you as a former prosecutor. So when they get that recommendation, Skico didn't act on it by going to Highlands and saying, we're breaking up. They did it. It's sort of the way that you get rid of a football coach that's overstayed. You give them a title, coach emeritus forever, but you're not allowed on the sidelines. They didn't seem to want to pull the trigger, so they gave them an offer, a fixed revenue percentage that was so low that they knew that Highlands couldn't take it. And so I wanted to throw that out. Does that, sort of the pretext or the subterfuge, is any of that, relevant to what we're discussing today?
Yes, I think it's relevant, but I think, in its opinion, talking about that case, I think the court, if I'm remembering this correctly, I think the court sort of says that something to the effect of, the facts here in this case, the Aspen ski case, were not as perhaps bold or predatory as Lorraine Journal, right? And so I think if you're moving down the line, you say, okay, that's not Lorraine Journal, and Lorraine Journal is really not the Kansas City case, then you can kind of start to see like, okay, this is, kind of where the lines are. And again, keep coming back to that, that level of egregiousness, boldness, kind of adding all of the different forms of anti-competitive conduct that a company could engage in to try to obtain and sustain that monopoly position.
And I do. I think the Supreme Court did say that. I've never fully understood where they're coming from, and I say that because you've got, on the one hand, leaving a joint selling arrangement or a joint marketing arrangement. I mean, right. You've got to have a lot of leeway there. And I think everyone sort of agree that, there's got to be more to it than that. But sort of the other acts of SKICO, beyond simply, we're done with this. Does that, does it add up? And in some ways, is it more egregious than Lorraine, where you have, you have Highland saying, we'll hire accountants to sit at the top of the mountain and count stuff, on our dime. No. Raising their own prices on daily lift tickets to make it, more difficult for Highlands to kind of bundle any package together, and angering their own customers. I mean, you get to a point where skiers are flying across the country, to go to trial to testify about how angry they are. Does that sort of conduct factor in, or are we still just, it's not quite Lorraine, and Lorraine isn't quite Kansas City?
Yeah, and I think, again, going back to, I mean, look, I think it all gets looked at, right? Because you're trying to, there's sort of multi-use of those types of facts in terms of trying to understand what the intent was, right? And what, how bad, how egregious was it? What was the actual, what was the intent? Was it clear? And I think kind of, again, the other point being just in terms of the history of criminal enforcement of Section 2, I'm not sure that that's kind of where we've seen over the 100+ years of the enforcement those are the types of cases where we've seen it. I think, and I don't know if I've talked about it directly yet today, but in my mind, as I think about kind of where this line is, you kind of have these two cases that sort of stand at one and the other ends of the spectrum of, where do you draw the line for criminal enforcement of the Sherman Act, right? Everybody knows you can do it civilly, you can do it criminally. And you have Nash in, 1913, where the court kind of first really took this up. It was Section 1 and Section 2, conspiracy to monopolize. And the court seemed pretty comfortable with the idea that, look, you have to make judgment calls, and that, as a business person, and that may get you in trouble. And that's okay. That there's not, the Sherman Act is not void for vagueness. And criminal prosecution's okay. Then I think you can go through, and there's all sorts of cases in between, but then you get to the Gypsum case, sort of the late 70s, where the court again sort of talks about Nash and talks about kind of where is this line, right? Because let's set aside, the court, I'm kind of paraphrasing the court here, let's set aside for a moment the classic per se price fixing, bid rating, market allocation cases, everything else, where is that line where the business person of, ordinary prudence isn't going to be able to appreciate what their actions, that their actions are criminal? Like, where is that space? And I think where the court went was just to say, look, there's going to be an elevated level of intent. And I think that's appropriate, because what we the court are concerned about is, there is, over prosecution. You're going to chill legitimate business conduct, right? And that's not what the Sherman Act was meant to do. There's also the individual issues in terms of prosecuting them for something that they couldn't have appreciated. And so, I think that's where, as I keep coming back to intent, and, I think that's why, in my mind, like, that's sort of an important demarcation. And it's in the course of that decision that you really see the court talking about, prior sort of statements from the Antitrust Division or from the Attorney General's Committee on Competition Enforcement, saying things like, look, we're focused on, situations where there's clear intent and egregious conduct. And I know those are kind of high level terms, and like what we're trying to figure out is, okay, brass tacks, like where does this translate into, something falling on one side of the line or the other? And, that's why I say, well, it ends up being very fact specific, but I think that's why the cases themselves are instructive. But just to give some context for why I keep kind of coming back to this idea of intent, that's where I see the case law, kind of the courts, the historical struggle of making sure that conduct being enforced under the Sherman Act, okay, here's what should be criminally enforced, and here's what is for everything else.
Travis, I love the case study approach to helping us better understand this topic. Although I think some of our listeners may be having flashbacks, some good, some bad, to their days as law students. Richard, what are the 3 key takeaways here for practitioners?
Sure. So first, while there are most often overlapping violations of Section 1 and Section 2, for example, conspiracy to monopolize, as we've discussed today, unilateral conduct may invite prosecution under Section 2 as well. And I think looking at recently filed cases can provide examples of this. So, for example, an invitation to collude that results in a Section 2 prosecution, even without an agreement. Second takeaway, as with Section 1, criminal sanctions are reserved for the most egregious conduct. So, for example, a standalone tying agreement, even one conferring market power in the tied product market, without more, is unlikely to invite criminal prosecution. And third, intent is key. Although historical precedent, including recent criminal enforcement actions, typically involved per se or other criminal violations, that shouldn't be interpreted to mean that those are the only ways we could see criminal prosecution under Section 2. Where there is clear intent and egregious anti-competitive conduct, there is a risk of criminal prosecution under Section 2. And that can be manifested in the bad acts or egregious conduct. But past conduct, for example, attempts to collude or to monopolize, may also factor into the intent analysis. So I think recidivism matters as well.
All right. Well, thank you, Travis and Richard, for this excellent discussion. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.